the entire Palestine team worked, god-awful hours for months, not taking vacations, not going home to see their family, working weekends. I've never seen people work so hard. It's a Hail Mary. They're just trying to throw stuff against the wall, and maybe they'll get lucky and invalidate the warrant. If Israel wins the appeal, Palestine essentially has to be kicked out of the court. A court that they have been a functioning member of now for 11 years. The ICC has a fairly long and ignoble history of unfairly raising the expectations of victims to then dash them. It's not easy being a judge of an international criminal tribunal. You know what the global consequences are of your actions.
Why is the US so opposed to the ICC, even though it was supportive of its early development?
There are plenty of situations in which the US has engaged in acts that could be credibly described as international crimes in areas that are subject to ICC jurisdiction. The US can harm the court, clearly, but they're going to harm the court over the objections of many of their traditional allies.
As an American who is engaging with the court, what's the risk to you personally?
I don't know whether the court would survive institutional sanctions. I despair often of how every conflict is initially viewed through the lens of the ICC. What's the ICC going to do? How is it going to get involved? When's it going to investigate? When's it going to bring charges? Of course it will in a number of situations, but it is just one international tribunal. Understaffed, under-resourced, constantly threatened, facing much more powerful adversaries. We need to get beyond looking at it as the court of first resort, and we really need to emphasize the role of states in pursuing international criminal justice.
On today's episode of Expert Witness, we're speaking to Jon Heller, a professor of international law and security at the University of Copenhagen's Center for Military Studies. Heller is a leading scholar of international criminal law and the special advisor on war crimes to the Prosecutor of the International Criminal Court. In this episode, however, he's speaking to us in his academic capacity. And this is to unpack the 15-year history of the Israel-Palestine war crimes probe at the ICC, leading up to the 2024 arrest warrants for Israeli and Hamas leaders. We will also discuss Israel's attempts to challenge the validity of the warrants, the impact of sanctions imposed by the Trump administration on court officials, and whether the ICC is really facing an existential moment with the looming threat of sanctions against the court itself. Professor Heller, it's a pleasure to have you here in London.
Pleasure to be here. Thanks for inviting me.
Thank you. First, can you describe what your role as a special advisor to the ICC prosecutor is? What does it entail in practice?
I think probably the most distinguishing characteristic is that it doesn't particularly have a structure. The prosecutor is entitled to appoint as many special advisors as he or she wants to. Some of them are thematic. So I'm a thematic special advisor because my remit is war crimes. Some are geographic specific, like special advisor for Darfur. And then some are considered without portfolio, which are basically they do whatever the prosecutor asks them to do. So technically, I am the special advisor on war crimes, and my expertise for the office is on war crimes. But within that, I serve at the pleasure of the office. If the prosecutor wants me to work on a particular situation or a particular case or anything, he asks me to do it. So more often than not, I will be advising the OTP, the Office of the Prosecutor, on war crimes issues, but I'm an international criminal lawyer, so I can talk to them about crimes against humanity. I can talk to them about genocide. My background is comparative criminal law, so I can talk a lot about that. It really just depends on what the office needs.
And can you talk a bit about what you've been doing in this capacity since you became a special advisor on
Sure.
war crimes, which was in 2021?
Yeah, so I've been a special advisor since the very beginning of Kareem's, the prosecutor Khan's term. I've basically worked on three major projects. The first one was working with two other special advisors, Lisa Davis, who is the gender persecution advisor, and Veronique Aubert, who at the time, she's no longer a special advisor, but she was the special advisor on children. And the first major project was writing a very long and very comprehensive legal memo, arguing that the Office of the Prosecutor should prioritize, in the Afghanistan situation, charges of crimes against humanity on the basis of gender persecution, with a particular emphasis on attacks on women and girls' education in Afghanistan. So we spent, the three of us, with a couple of excellent law students, a number of months putting together that memo. And as you may know, in fact, those charges were ultimately included in the applications for the arrest warrants and really do kind of form the centerpiece of the arrest warrants for the two very high-ranking Taliban suspects. So that was the first thing. The second thing, which took up a lot of time over almost 2 years, was he asked me to lead the development of the recently issued, well, we called it the Policy on Environmental Crimes for a long time. The actual name, because of all kinds of internal politics, ended up being the Policy on Addressing Environmental Damage through the Rome Statute. And so I, as special advisor, led the development of that process. I co-authored the policy itself with a fantastic appellate attorney in the Office of the Prosecutor, a man named Reinhold Gallmetzer. And we had another member of the office, Helen Worsnop, who is kind of part of the core team, and a phenomenal legal fellow who is a Colombian attorney named Laura Barron Mendoza. And the four of us essentially spent 2 years creating this policy. And we launched it formally at the Assembly of State Parties in December in The Hague. So that, at least that phase of it is now complete. And then, of course, the third thing that I have worked on, not so much over the past probably 6 months, but really for quite a long time, was working on the Palestine investigation. I was brought into that by the prosecutor really the day after October 7th, and to some extent even before that, because of course the office's investigation long predates the events of October 7th. So I have done other little things along the way, but those are really the three major projects that I've done in my, now 4.5 years as a special advisor.
That is quite incredible, by the way, given the fact that this is mainly a pro bono position, right? And
yes, it's completely pro bono.
Yeah,
the only thing,
academic.
Occasionally, when I have to travel for business, I get a daily service allowance, which is enough to cover basically, food and accommodation, and they would pay for flights. But there's no salary ever paid to any of the special advisors. We all serve pro bono.
So, speaking of the Israel-Palestine investigation, which I'm mainly interested in discussing in this episode. You started your role as a special advisor in 2021, which was, I guess, around the time that the investigation was launched, or was due to be launched?
If you look at the overall scope of Palestine's interactions with the court, it goes actually all the way back to 2011. But in terms of opening a formal investigation, that did not happen until 3 months before Prosecutor Khan assumed office. So very much at the end of her tenure, Fatou Bensouda formally opened the Palestine investigation. So when Prosecutor Khan took it over, it was really in its infancy.
And this is despite the fact that the process of initiating this investigation was like 15 years in the making, but the actual the arrest warrants only took place after October 7th. So could you walk us through this history? Why has it taken so long to actually to bring arrest warrants against Israeli leaders or Hamas leaders, even though the state of Palestine acceded to the Rome Statute in 2015, and like they have been trying to trigger a serious investigation for many years before a prosecutor.
15 years, really.
Yes. So why is this the case? Why has it taken so long?
Well, I need to preface the answer, of course, by I was not working in the OTP prior to Prosecutor Khan.
I know.
So my knowledge...
But you do have a lot of knowledge on this
Oh, no, of
subject.
course. But I just want to make clear that my knowledge of what happened before 2021 comes from the fact that I'm an academic and that I spent a lot of time following the court, particularly in this situation. So I don't have any insider information about what happened before 2021. As you noted, it is a long and I think some would say torturous process. 2 referrals, and joining the court, self-referral. We could go all the way back to Luis Moreno Ocampo, and he could have opened the investigation, very early on.
The founding prosecutor of
the first prosecutor of the ICC, right? He ultimately decided that it was not for the office of the prosecutor to decide whether Palestine qualified as a state for purposes of membership in the ICC. He said that was for the Assembly of State Parties, or probably more likely for the United Nations. So he basically just punted. But he punted after essentially sitting on the investigation for 3 years. I don't know what was going on behind the scenes, but certainly it didn't seem like very much was going on from the time that Palestine asked the court to investigate to him finally announcing he was closing the preliminary examination. So you lost that 3 years. Then you had the second prosecutor, Fatou Bensouda. She also could have, I think, quite quickly opened the investigation. For whatever reason, she did not. The analysis of whether the statutory criteria under Article 53 are satisfied took them about 5 years. Eventually, they did conclude that those criteria were satisfied, and many of us, again, on the outside, thought, okay, now she's going to open the investigation because the preliminary examination has been concluded. She has found the statutory criteria is satisfied. But then, again, erring on the side of caution, and in my academic capacity, I very much described it as an error, she decided that instead of opening the investigation, she would ask the pretrial chamber to essentially render an advisory opinion on whether or not there was jurisdiction in the situation. Was Palestine properly a member of the court? They had obviously acceded to the Rome Statute in 2015. We're now in 2019. And if so, what was the territorial scope of Palestine for the situation, for the investigation itself? That took another year. I very strongly, in my academic capacity, criticized that decision. My perspective, and I still think that I was right, my perspective was that she didn't need to do that. That would have been for a suspect to ultimately challenge. I mean, the suspects have every right to challenge the court's jurisdiction. So why do the defense's job for it? Just open the investigation, eventually bring charges against somebody, and then know that you're going to have to fight over the membership and the jurisdictional issue. She didn't do that, and I'm sure we'll talk more about it, but we still have to fight over the membership and the jurisdictional issue. It didn't go away. But ultimately, after a year of litigation, the pretrial chamber said yes. For purposes of the Rome Statute, Palestine is a member in good standing. Now, they wanted to be very clear that their decision was not for any other purpose than membership in the court. They were not saying that Palestine was a state under general international law. They were saying that Palestine was a state for purposes of the Rome Statute. I'm not sure how many people really bought that distinction. I certainly don't buy it, but that was their decision. So ultimately, they said yes, they're a member in good standing. Ultimately, they said that the territorial jurisdiction of the court extends to the entire, occupied Palestinian territories, including East Jerusalem. And at that point, having concluded that the statutory criteria were satisfied, having an advisory opinion from the pretrial chamber that they were members in good standing and that there was territorial jurisdiction in those areas, then, again, right before the end of her term, she finally said, okay, I'm going to formally open the investigation. And then essentially bequeathed it to Prosecutor Khan.
Arguably, the post-7 October context or events have contributed to accelerating the arrest warrant applications. Would you argue that that we would have seen arrest warrant applications without the events of 7 October?
Yes, I think we would have. I definitely don't disagree with you that October 7th gave new impetus to the whole process. But it's also very important to understand that having been bequeathed the investigation, Prosecutor Khan really made it one of his first real commitments. When he was given the investigation, there were no staff assigned to the Palestine investigation. There was no money allocated to the Palestine investigation. The next year's budget for 2022 had already been prepared by Prosecutor Bensouda, and it didn't ask for any money for the Palestine investigation. And at that point, it was too late, essentially, to try to redo that entire budget. So he inherited the investigation with nothing. But despite that, he immediately made it a priority to push that investigation forward. He started assigning staff to the investigation. They started like the kind of recruitment process, anticipating that they would in fact have funds to hire people to strengthen the team when the 2023 budget was coming due. He even he went to New York, I think it was in New York, and said to the Assembly of State Parties that he was essentially stealing resources from other investigations to fill out the Palestine team because he didn't have any dedicated budget. So he pushed it forward immediately. And this again was almost 2 years before October 7th. So it was a priority for him long before the actions on October 7th and then the actions that Israel took in the wake of October 7th. So I think it still would have gotten to the point where there would have been arrest warrants. It definitely did contribute to a sense of urgency, October 7th and the aftermath of it. So, counterfactuals are impossible to prove, but I feel pretty confident saying that train had left the station and it would eventually have led to something similar to what we've seen.
As an insider, Professor Heller, to this process of seeking arrest warrant applications, can you talk us through this process, like legally speaking, because there have been allegations that, for example, the applications have been rushed to cover up alleged sexual misconduct.
I hope we'll come back to
claims.
That issue, because that kind of needs its own answer.
Yes, we will. But can you just explain what does this application process entail exactly?
I mean, obviously there's some things I can't discuss, but I can talk about the process in general. And the first thing to emphasize is that the investigation didn't start on October 7th. It didn't even start in 2021. The preliminary examination process, which lasted an embarrassingly long time, was still also an investigative step. Not a formal investigation under the Rome Statute, but when you're conducting a preliminary examination, what you're doing is you're looking at evidence and you're trying to decide, if I open this investigation, are there concrete suspects? Is there enough evidence that I think I can eventually get a conviction? So it is a long, slow process of building up the evidence. It doesn't matter when a formal investigation is opened, because the OTP then has a whole bunch of statutory powers that it doesn't have prior to that moment. But it is still a continuation of that work. So again, before October 7th, it would have been receiving information from NGOs, open source intelligence, talking to the families of victims who didn't survive and victims who did survive, talking to witnesses, all the things that you do when you were building a criminal case and trying to identify, first, who are the suspects that we think are the most responsible, who are the suspects that are most responsible that we think we have enough evidence to eventually convict, although, you don't actually have to reach that standard initially, but ultimately the point is to get somebody in the dock and convict them of international crimes. And then there's also a very difficult process of what do we actually charge these suspects with? Which war crimes? Which crimes against humanity? And that's an endlessly recursive process where you have hypotheses and you develop an evidence, and then maybe you change one suspect. It doesn't seem like it's going to be possible to prove their guilt, so you move on to another suspect, or this is the suspect, but we don't think these charges are going to pan out, so we're going to shift to another one. And you just build up the case. And at a certain point in time, and again, we can break this down more if you want, at a certain point in time, you feel like you have a reasonable set of suspects, you have a reasonable set of charges, and you're ready to actually submit an application for an arrest warrant to the pretrial chamber. That is the first stage in the investigative process.
And the prosecutor also brought in the external expert panel. What was the rationale for that, do you think?
It's unquestionably the case that kind of panel had never been used at the ICC. They had been used at the ICTY, at the International Criminal Tribunal for the former Yugoslavia. It was essentially another set of highly skilled eyes. Everybody was aware of the scrutiny that was being paid to this investigation. Everybody was aware of the potential consequences for seeking arrest warrants. There is an endless amount of internal vetting of applications that go on, but we all know there is no substitute for a fresh set of eyes. And so at a certain point in time, very, very far into the investigative process, he decided that he would bring in a panel of experts who have no preconceptions, who have not seen any of the evidence, who have not seen any of the 50 earlier drafts of the applications, to just sit down and spend a very significant amount of time being shown the evidence and being asked to read the applications and asked for their feedback. They're a red team, essentially. Poke holes in what the applications contain. Tell the prosecutor where the evidence isn't strong enough. Tell the prosecutor where there needs to be more investigation. Tell the prosecutor if you think these charges are not the best charges, there should be different charges. And then that triggers yet another round of drafting. Invaluable feedback from some of the best attorneys in the world. It only makes the application stronger.
Were you surprised when the judges eventually issued the warrants, despite the immense political pressure and threat of sanctions?
I wasn't surprised at all. Obviously, no one's naive. Everybody understands, the pressure put on the court and on the judges in particularly this situation. Although not only this situation, but I trust the judges to be professional and do their job and make a decision based on the evidence that is presented in the application for the arrest warrants. And, having been involved in the preparation of those applications, I had no doubt that we would get the arrest warrants for all of the suspects. And I suspected that we would get the arrest warrants for an overwhelming majority of the specific charges. And that's exactly what we saw. We saw complete unanimity by the pretrial chamber. There was no dissenting judge, and they issued the arrest warrants on, I think, I haven't calculated it, but probably 90 to 95% of the charges that they were asked for. I can't talk about, why they didn't issue it on the crime against humanity of extermination charges, and why they rejected the application on a couple of what we would call conduct of hostility charges, actual attacks on civilians. But it was an overwhelmingly successful set of applications, again, on both sides, for the Hamas leaders and also for the Israeli leaders. And that was the right decision because the evidence, well, first, it's a fairly low standard to get an arrest warrant. It just has to be, a reasonable grounds to believe that the suspect is responsible for the crimes. Prosecutor Khan, as a matter of policy, not as a matter of law, actually holds everyone to a higher standard. He says unless there's a reasonable prospect of conviction, I'm not going to move forward even at the arrest warrant stage. So not only did the evidence satisfy the statutory standard, it also satisfied his policy-based higher standard. It was overwhelming. I mean, I wish that people could see the application. Applications for arrest warrants, I think there's this perception out there that, the OTP, a prosecutor just wanders over to the judges and says, hey, can I have an arrest warrant for suspect X? It's not the way it works. These are incredibly long, detailed documents supported by massive amounts of evidence. You as low of a standard as it is, you don't want judges to be rejecting your applications, even though you have the right to go back, of course, and supplement them and submit them again. It's still embarrassing. You want to get the arrest warrant the first time. And, these warrants were long, or the applications were long, complicated, and supported by massive amount of evidence that was, collected from a whole variety of sources. It would have been nice if Israel had allowed the prosecutor into Gaza to actually do investigation on the ground. He asked innumerable times, and every time was refused. But months and months of investigation and analysis went into these applications, and they involved everything from testimony of victims and witnesses and NGO workers and doctors and lawyers who were actually on the ground in Gaza. The investigation relied on a massive amount of audiovisual evidence, recordings, video recordings, mobile phones, all of which were uploaded to the OTP via the secure encrypted link that allows anyone in the world to submit evidence of any crime. All of that then processed by really cutting-edge artificial intelligence and machine learning technology. Open source information, satellite imagery, statistics from NGOs working on the ground in Gaza and in Israel and in the West Bank, international organizations who have a presence there or who study and focus on Israel-Palestine. And then, of course, the big one on both sides of the situation, inculpatory statements from the suspects. When suspects say things that make it clear that they have committed crimes, of course, that becomes incorporated into an application as well. So all this evidence collected over many months then leads to a very comprehensive, very well documented application for an arrest warrant. And I was totally unsurprised when the warrants were issued. I would have been shocked if they were not issued because there was no legal basis for not issuing them.
In April of last year, judges at the International Criminal Court decided that all new arrest warrant applications would be filed under seal or without being publicized, as had been the case under the leadership of Prosecutor Khan. How do you feel about this decision, and is it in the interest of victims and the transparency of the process?
It's an excellent question. I have to preface my answer by saying this was within the rights of the judges to do. It's not a lawless decision. I understand why they might do it. I do think it is unfortunate. It does also need to be said that, it was not unprecedented for Prosecutor Khan to announce the applications for the arrest warrants in the Palestine situation. He had done so previously in Georgia. Luis Moreno Ocampo, the first ICC prosecutor, he had publicly announced at least a couple of applications for arrest warrants, but it wasn't normally done. It was more common to not discuss publicly the filing of applications and really only discussing particular arrest warrants once the pretrial chamber did, in fact, issue the arrest warrants. But I do still think that there are times in which the Office of the Prosecutor should be able to announce applications, particularly in situations of ongoing conflict. I'm putting my academic hat on. I don't think that the ICC has a massive deterrent effect on the parties to a conflict, but it doesn't have none. I think there is a time and a place in the middle of atrocities for the Office of the Prosecutor to say, hey, you should know that I'm not just monitoring the situation, which is what they always say. I'm not just monitoring. I am actually seeking arrest warrants for high-ranking officials in your government or your organized armed group, and just be aware that you could be next. I think that does potentially have deterrent effect in certain circumstances. And I think losing that possibility is unfortunate. I do agree in general that applications should be filed confidentially. But the prosecutor should have...
Why is that the case?
Because if there really isn't a concrete reason to announce them, such as trying to deter ongoing atrocities, I do think that it's best to let the pretrial chamber judges work in peace. The ICC's decisions in any situation are high stakes and often quite controversial. It is a difficult situation to put judges in, to let the world know that those judges at that very moment are considering issuing an arrest warrant for maybe a sitting head of state in a powerful government. I am very sympathetic to the situation the judges find themselves in. So I have no problem with the presumption of confidentiality. I do think it goes a little too far, even though it's within their rights, to say never. Because, again, I think there's a time and a place for trying to get some deterrent effect by announcing applications.
Don't you think it's unfair for the victims and witnesses not to have these applications public?
I think that might be a little too simple. If the applications are going to be granted and the arrest warrants are going to be issued, and the arrest warrants are going to be issued on all or mostly all of the charges that would have been announced publicly by the prosecutor, then sure. That kind of transparency is good. It is good for victims to know that the office is not just sitting, twiddling its thumbs. And it often gets criticized for not acting, when really what's going on is that there's actually a lot going on. It's just behind the scenes that people can't see. So I totally get, and I don't want to dismiss the transparency argument, but you can never be certain that the chamber is going to issue the arrest warrant. You can never be certain that they're going to issue the arrest warrant on all the charges that are sought. And I think the ICC has a fairly long and ignoble history of unfairly raising the expectations of victims to then dash them. The court has had its successes, but it's also had a lot of failures. And I think it could be truly devastating to announce that an application for arrest warrants have been filed, getting the hopes up of all of the victims, again, whatever the side, whoever the suspects and charges are, only for in the end the judges to say, no, sorry, there's not enough evidence here. I think that's often worse than them not knowing what's going on behind the scenes. I think that's probably the best answer I can give.
But
you can't ever be certain that you're going to win any stage of the process at the ICC.
Don't you think that not publicizing the warrants actually is a missed opportunity somehow to put pressure on judges to issue the decisions quickly? I know you mentioned that the judges should not work under such pressure, but isn't it in the interest of the process and its transparency and its integrity to try to issue these warrants as soon as possible?
I'm very sympathetic to the ends. I'm not sympathetic to the means. I have written innumerable times over the years as an academic that the ICC moves too slowly, that the judges take too long to issue decisions, that things need to happen more quickly. I would love nothing more than the judges to speed up the process. I think public shaming is the wrong way to go about it. I think a much better way would be for interested NGOs and activists and states to really lobby the judges to amend their own internal rules to impose deadlines. Perhaps extendable for emergency situations or incredibly complicated cases, but internal regulations that say that judges have to issue a decision on an arrest warrant within X amount of days, or they have X amount of months to complete the judgment in a particular trial. That kind of reform is extremely healthy. I think that's a better way to do it than the public shaming, because it's not easy being a judge of an international criminal tribunal. You know what the global consequences are of your actions. Nobody in that pretrial chamber was not aware that their lives were not going to be the same if they decided to issue the arrest warrants for Netanyahu and Gallant. And so I think the job is tough enough without trying to shame them into acting more quickly. They should act more quickly, but they should act more quickly because they have decided they have to act more quickly, not because they've gotten pressure from the outside.
There are a number of allegations that Prosecutor Khan rushed the applications. But on the other hand, there are accusations that he actually acted too slowly. And of course, there is the claim that the move was partly as an attempt to cover up for the sexual misconduct allegations. Can you address these claims and whether you find them plausible or unfounded?
Sure. You won't be terribly surprised to learn that I reject them all. But let's separate them for a second. It's not terribly surprising that some people wanted him to move quicker, and it's not terribly surprising that some people wanted him to move more slowly. I have a certain sympathy for the people who say that he should have acted quicker. Obviously, this had been going on for 15 years, this entire situation. There were plenty of times when his predecessors could have moved forward more quickly and brought charges themselves. I think the fact that he inherited nothing in June of 2021 and ended up bringing charges in May of 2024, again following a massive tragedy involving criminality on both sides. These things take a while. If you could have taken October 7th and the reaction to October 7th out of the equation, you probably could have fairly expected arrest warrants more quickly than that. But once that happened, you do have to give enough time to carefully investigate a very complex set of international crimes. So I don't think realistically it could have happened any more quickly. It wasn't like anybody was sitting around twiddling their thumbs instead of investigating. I mean, I can assure you the entire Palestine team worked god-awful hours for months, not taking vacations, not going home to see their family, working weekends. I've never seen people work so hard. It's an unanswerable question, right? Like, what does it mean to move more quickly? More slowly? Again, I don't think there's a way to judge that. You move forward when you have enough evidence to move forward. You can always investigate more. You're a journalist. You can always keep editing your story. There's never a natural stopping point. If you want, you can keep researching. You can do another draft. You can expand it. You can contract it. At a certain point in time, you have to say, this is as good as it's going to be in a realistic time frame. And that's ultimately what the prosecutor decided. At a certain point in time, he felt comfortable saying that the evidence against the 3 Hamas officials and the evidence against the 2 Israeli officials had been developed to the point where the applications were strong enough to go to the judges. And again, not to the lower standard, but to the reasonable prospect of conviction that he imposes as a matter of policy. He could have kept going forever. He could still have been investigating today, but at a certain point in time, and this is why you're elected to be the prosecutor, you have to make that difficult decision to say, this is it. We're going to file on this date. And it's very easy to second guess that, or in the United States, as we would say, to be a Monday morning quarterback of those decisions. But that was the decision he made. He said, now we're ready and we're not going to do any more. And I, again, because I think of the strength of the warrants or of the applications, that made sense. I've had journalists tell me over time, like, well, there's allegations that the investigation was rushed, that the evidence analysis was shoddy, and he should have taken more time. And my response is, well, the warrants were issued unanimously by the pretrial chamber on like 90 to 95% of all of the allegations. What other criterion to judge whether there was enough investigation is there other than the judges approving it? If the judges had rejected the warrants, or if they had said, we're going to issue the warrants, but only on, I don't know, I'm making these numbers up, 2 out of 10 charges or allegations, then I would say, okay, you've got a pretty strong case to say that this was rushed. That didn't happen. In the most politically heated situation in the history of the ICC, at least with the Israeli defendants, the most momentous decision that judges would ever have to make in their 9 years on the bench, they all unanimously agreed that the evidence supported the arrest warrant on almost everything that it was asked for. What other way to judge there is that? The proof of the pudding is in the eating. We got the arrest warrants. That's, to me, the end of the story for claims that he moved too quickly. So that's those two claims. I think the most ridiculous claim of all, and I choose my terms very carefully, is the allegation that somehow he filed these applications to distract from the sexual misconduct allegations. That is simply irreconcilable with the timeline. A timeline that, not coincidentally, Middle East High has helped establish in the public domain. There's two fundamental problems with that argument. The first one is that, and this is public knowledge, I'm not giving any away state secrets, it is public knowledge that these applications were being worked on long before there was any inkling of any misconduct allegations against him. This team didn't start working in whatever March or April on these applications. It was months before that. So that part of it is just silly. The equally ridiculous, but at least a facially plausible claim is that he chose the specific date to file the applications, or he brought the process to a close to distract from the sexual misconduct allegations. Because obviously he was aware that there were allegations before May 20th, 2024, when he filed the applications. But what's ridiculous about the claim is, again, look at the timeline. On May 20th, 2024, when he filed the applications, there was no active investigation of any misconduct allegations. IOM, the independent oversight mechanism, the statutory office that investigates all allegations of misconduct, had informed the prosecutor that the investigation was closed. The complainants did not want to cooperate with IOM, so they, because they're a victim-centered organization, they closed the investigation. That's what happened before May 20th. All he knew was that these allegations had been made, IOM had looked at them, and IOM was not proceeding. There was nothing to indicate that there would be, leaks to the press about the misconduct allegations, that eventually the Assembly of State Parties, through the president, would outsource the investigation to the UN's Office of Investigative Services. None of that was live when he made the decision. That wasn't actually for another 4 or 5 months. So he could not have been distracting from allegations by filing the warrants, because there were no active allegations against him, no misconduct investigation when he made that decision. So it just doesn't stand up to really even a cursory look at how all of these events unfolded.
So now I'm going to turn to the challenges that Israel has lodged against the warrants, or attempting to invalidate the arrest warrants. One of them was rejected by the appeals chamber in December. Can you outline Israel's main arguments?
So that particular challenge was about the principle of complementarity. The principle of complementarity is really central to the court. It basically says that the ICC is designed to be a court of last resort. It is not designed to supplant national jurisdictions when those national jurisdictions are genuinely investigating the right suspects for the right conduct. So the essence of the argument is that the Office of the Prosecutor should have deferred to Israel to allow Israel to pursue national investigations. When the Office of the Prosecutor makes a decision to open a formal investigation, preliminary examination is complete, and the prosecutor announces, I have completed my preliminary examination. I am going to formally open an investigation into situation X. At that point in time, the prosecutor sends a letter to all of the concerned states, particularly the state that, whose nationals are being investigated or on whose territory the crimes were committed, sends them a letter basically saying, these are the results of my preliminary examination. These are the types of cases that I am going to investigate. You don't necessarily have specific suspects at that point in time. You might have a vague idea. These are the kinds of crimes that I think have been committed in this situation, and these are the kinds of crimes that I'm going to be looking into. When the prosecutor does that, it's called an Article 18 notification. The state who receives that letter has 1 month to actually formally ask the Office of the Prosecutor to defer the investigation. They're entitled to ask the OTP to defer the investigation on the ground that they are already themselves investigating the kinds of suspects and the kinds of crimes that the OTP has identified in this letter as the objects of the investigation. And we've seen a number of states do this. Venezuela did it. Afghanistan did it. The Philippines did it. When a state receiving an Article 18 notification asks the OTP to defer, the OTP has to defer. They have to put down their pens. They can't do anything. They're statutorily barred from proceeding in any way until such time as the prosecutor goes to the pretrial chamber and says, this was a ruse. This was a sham. They're not really genuinely investigating the kinds of cases and kinds of crimes that we're looking at. They're just stalling, essentially. And to date, no Article 18 deferral has lasted all that long because they weren't actually intended to allow national processes to go. But that is a formal part of the process. Israel had every right in 2021, when Prosecutor Bensouda sent them an Article 18 letter, to say, hey, we're going to handle this domestically. Maybe eventually the investigation would have restarted, but the OTP would have had to stop doing anything in the Palestine situation. Israel never did that. They never took advantage of that opportunity.
Why do you think that's the case?
Because at the time, two aspects. At the time, they had a no interaction with the court policy. The only answer that they would ever give to any communication from the court. And the Office of the Prosecutor had been reaching out to Israel for years, not just under Prosecutor Khan before October 7th, but under Prosecutor Bensouda before the formal investigation was opened. They had always had the same answer. You don't have jurisdiction. We're not going to interact with you. So the main reason was they stuck to their position that they don't have to engage under Article 18 because there's no jurisdiction. I mean, the OTP went so far as on the final day of the 1 month period that Israel had to ask it to defer, it actually sent it another letter saying, are you sure? You sure you don't want us to defer? You sure you don't want to invoke your Article 18 rights? Silence. No response. So they didn't take advantage of this opportunity to invoke the principle of complementarity. The stated reason was, we don't think you have jurisdiction. And to be fair, they don't. Israel clearly, they weren't making that up. They did believe that there was no jurisdiction. But I also think very strongly, and this is my own particular interpretation. It's not an official position or a stated fact. I believe they never invoked Article 18 because they never thought that a prosecutor, Bensouda or Khan or whomever would be elected after Bensouda stepped down, they never believed that they would actually have the temerity to bring an application for arrest warrants against any Israeli official, much less the high-ranking ones that were ultimately the object of the investigation. They said, we don't think you have jurisdiction, and we're not going to engage because we don't think this is going anywhere. Well, they tragically miscalculated. They underestimated Prosecutor Khan's commitment to bringing justice in the Palestine situation to both sides, and his willingness to seek arrest warrants for high-ranking Israeli officials, even though he was fully aware what the consequences could potentially be. So that's the background. You can't understand what's happening in the current challenges without understanding that background. What Israel has said, and this is the appeal that they lost, what they said was, October 7th changed everything. The investigation that the OTP launched after October 7th is so fundamentally different than the investigation that Bensouda had been conducting and Moreno Ocampo before her, that the original Article 18 notification in 2021 wasn't enough. They said that this was a new situation. Yes, it was still Israel-Palestine, but it was a new situation, and that Prosecutor Khan should have issued another Article 18 notification saying, these are the kinds of cases and these are the kinds of charges I'm going to look at in the wake of October 7th. And they said because he didn't do that, they were deprived of their right under Article 18 to invoke complementarity and ask the OTP to defer the investigation. And because of that deprivation, the arrest warrants should be canceled. That was never going to succeed, and it didn't succeed. That some of the crimes committed on October 7th and after were different than the crimes that were under investigation when Bensouda issued the Article 18 notification, when she first opened the investigation. But they're not fundamentally different. It's still Israel-Palestine. It's the same geographic location of the crimes. It's still the IDF, Hamas, and Palestinian armed groups. Many of the actual charges were being investigated long before October 7th. So what both the pretrial chamber and the appeals chamber said was, this is still the same situation. Israel certainly knew enough about the kinds of suspects and kinds of crimes that the OTP was looking at before October 7th, that if they had wanted to invoke the principle of complementarity, they could have started their own investigations, even of October 7th and post-October 7th conduct. So they just rejected that completely, that particular appeal.
And how about the two other challenges?
So the two other ones are still ongoing. Let me start with the really frivolous one. The most recent and the most frivolous one is about disqualification of the prosecutor, which is a little ironic because, of course, he has temporarily stepped aside and has not been the actual functioning prosecutor for, 7 or 8 months now. What they said was that, I have a hard time even summarizing the allegations because they make absolutely no sense, that somehow because he rushed to judgment and because he ignored what Israel thinks is exculpatory evidence, that somehow he was biased against Israel, and because he's biased against Israel, he should be disqualified from any future interaction with the case, and because he didn't disqualify himself, somehow the arrest warrants should be invalidated. We could talk forever about the problems with that appeal. There is no basis to disqualify him. There's no conflict of interest. He's a prosecutor who believes in the charges that he brought and believes in the investigation that he and his team conducted.
He did work on many other situations.
Yeah, exactly.
Ukraine,
he was the prosecutor.
Myanmar and
Precisely.
Philippines and Venezuela.
Absolutely. And he has been disqualified from other situations, but based on very concrete conflicts of interest about previous work on issues related to the situation or a family connection that the judges thought was too close, concrete reasons to disqualify him. I don't agree with those decisions, but they have a plausibility to them. There's nothing equivalent here. Basically what they're saying is he wants to convict people he thinks the evidence supports the charges against too much, so he should be kicked off the case. That doesn't make any sense. Even in the unlikely event that judges thought that there was some kind of conflict or some appearance of bias and disqualified him, that still has nothing to do with the arrest warrants. The arrest warrants would still be completely valid. It would just be, whoever was in charge of the office of the prosecutor at the time that he was disqualified, they would be the ones responsible for conducting the ongoing investigation. There's no connection between those two things. It's again, to use an American football term, it's a Hail Mary. They're just trying to throw stuff against the wall and maybe they'll get lucky and invalidate the warrants. So that one has zero chance of success. The other one that is still pending, I also think has no prospect of success, but it is a much more serious appeal. And it really is the jurisdictional challenge. As I said before, the pretrial chamber in 2019 did issue, or actually in 2020, issued a judgment saying that Palestine was properly a member of the court and that the court had territorial jurisdiction over the entire occupied Palestinian territory, including East Jerusalem. But they're the pretrial chamber. They don't have the final say. And they made clear that there would be time in the future where these issues could be litigated again. And that's where we are. Israel has absolutely, I may not think that these are powerful pieces of legal argumentation. I may not think that they have a prospect of success, but Israel has every right under the statute to particularly bring this appeal. They're like any other state whose officials are being investigated. They have the right to challenge jurisdiction, and that's what they have done. They've basically asked the appeals chamber to disagree with what the pretrial chamber had decided in 2020. Again, I think it is extremely unlikely that the judges are going to find that there is no jurisdiction. I don't know exactly what the reasoning will be to get them there, whether they will do we're not talking about Palestine as a state under general international law, we're only going to talk about it for purposes of the Rome Statute. I don't know how they're going to get there, but I will be profoundly shocked if they throw everything out. And that's the consequence. And it's important to understand that. If the appeals chamber were to rule for Israel and they conclude there was no jurisdiction in the Palestine situation, that really has to be based on the conclusion that Palestine is not properly a member of the court, that they had no right to join the ICC. So if Israel wins the appeal, Palestine essentially has to be kicked out of the court. A court that they have been a functioning member of now for 11 years. They've been paying dues. They've been participating in the Assembly of State Parties. They've had their nationals elected to positions within the Assembly of State Parties. The appeals chamber would have to say, all that was a mistake. You never should have been allowed a seat at the table, and we're kicking you out and presumably giving you all of your, all the money that you paid in dues back to you. I don't see them doing that. I also think, and again, my speculation, I think that it's a sign, and a bad sign for Israel, that the judges on the appeals chamber issued the Article 18 decision first. If they were going to conclude that Israel's technically Article 19, if the judges were to conclude that Israel's jurisdictional challenge was valid, there was no reason to decide the Article 18 appeal. Complementarity is irrelevant if Palestine is not properly a member of the court and the court doesn't have jurisdiction over the crimes in Palestine. The fact that they went to the trouble of rejecting the Article 18 first is a pretty strong sign, I think, that Israel's going to lose their jurisdictional challenge as well. Why waste all that time on an issue that is moot if the jurisdictional challenge has merit? So I don't know when we will see the appeal judgment issue. It is, I think, frustrating that it has taken so long. It's been pending, I think, for at least 7 or 8 months. But I am quite confident that it will not lead to the annulment of the arrest warrants and the kicking out of Palestine from the ICC.
Professor Heller, at the beginning you mentioned that part of your work as a special advisor included working on Afghanistan and the applications against members of the Taliban. Relatedly, the Afghanistan investigation has been one of the main causes of the US attacks and sanctions on the court. So I want to hear from you on the history of that, the roots of this turbulent relationship between the United States government and the International Criminal Court. Why is the US so opposed to the ICC, even though it was supportive of its early development?
It is a unique kind of American schizophrenia. The US has been one of the driving forces behind the literal existence and evolution of international criminal justice from Nuremberg on. It was very active in the negotiations over the International Criminal Court. The U.S. likes to get its way. The U.S. likes international institutions to acknowledge, accept, recognize, reflect U.S. preferences for how international criminal justice is carried out. All the previous courts and tribunals from Nuremberg on, they were all about one conflict, ones that the U.S. was not involved in. They were all about one side to a conflict. They were not courts that ever had any prospect of prosecuting Americans. The Yugoslav tribunal, the prosecutor briefly looked into actions of NATO, but I don't think anybody thought that was ever going to really lead anywhere. The ICC is different. The ICC is a court of general jurisdiction. It, in theory, could have jurisdiction over every international crime committed by any human being anywhere in the world. It doesn't, of course, but that's the underlying idea. That's its potential. There are plenty of situations in which the U.S. has engaged in acts that could be credibly described as international crimes in areas that are subject to ICC jurisdiction. It's not just an abstract possibility of the ICC ever prosecuting an American. And it's that possibility that is just completely unacceptable to the U.S. They will not support an institution that could ever conceivably hold an American to account. And I'd love to give you a big, fancy, long, complicated answer about the U.S.'s relationship to the court, and there are specific, provisions in the Rome Statute it didn't like, and so on and so forth. But really, it ultimately boils down to that. They just don't want one of these foreign institutions to ever have an American soldier or an American political official in the dock. And insofar as that becomes even a remote possibility, the U.S. will act to neutralize that institution. And that's exactly what we've seen. Again, different levels of hostility to the court over the court's existence. Democrats usually a little bit more willing to work with the court when interests align. Republicans usually less willing, although even in the second Bush term, there was a lot of cooperation with the court. Once it gets to the possibility of Americans ending up in the dock, it's a truly bipartisan position to oppose the court. That's different, of course, than actually issuing sanctions against individuals at the court. That is really a uniquely Republican phenomenon. And it's not just a Republican phenomenon, it's a Trump phenomenon. Not even in the worst days of the Bush administration's relationship to the court, was there ever really a serious prospect of seeing this kind of attack on the court? This is about the people in the Trump administration and the president himself. But that's ultimately what it boils down to.
And yet the U.S. has actually supported a number of investigations, like
Absolutely.
yeah,
I mean, over
Libya and
Darfur
Sudan
is a
and
really
others.
good example.
Yeah.
They were very supportive of Darfur. They've been very supportive of the investigation into the Lord's Resistance Army in Uganda. It was kind of like enlightened opposition, right? Other than Trump, again to different degrees, when the interests of the court overlapped with the interests of the United States, the U.S. was generally willing to help the investigation. The most dramatic example of that, of course, is the arrest warrant for Vladimir Putin. The U.S. was over the moon when Prosecutor Khan issued or filed that application and that those arrest warrants were issued. Lindsey Graham, who is like the leading attack dog against the court, couldn't say enough good things about the ICC when it went after Vladimir Putin. The U.S. Congress actually allocated money for the Ukraine investigation, the first time that had ever happened in the history of the court. But of course, Putin is, well, except for our current president, is widely seen as an enemy of the United States, that the Russian interests are opposed to American interests, and America generally on the side of the Ukrainians. And that was a perfectly safe investigation for the U.S. to support. When it comes to Afghanistan, when it comes to Palestine, the situation is very different. And that's why we've seen really what can only be described as the blatant hypocrisy of the United States in falling all over themselves to praise the court with Putin and then falling all over themselves to try to destroy the ICC when it comes to Netanyahu and the completely abstract and unrealistic prospect of any actual prosecution of an American in Afghanistan. So,
what did you make of the Assembly of States Parties position to resist or shun the Trump administration's pressures or attempts for the courts, states parties, to basically drop the Israel investigation, to end the Afghanistan investigation, and even to amend the Rome Statute to prevent the prosecution of nationals of non-member states. I reported on this during the latest ASP in December, where you were there as a special advisor, but I was there as a reporter. And like diplomats I spoke to have mentioned that the vast majority of members of the Rome Statute have rejected U.S. pressures to like these three pressures mainly. So what do you make of that, and is it an indicator that states parties are going to stand up to the Trump administration in the future?
Would be loath to make predictions about what will happen in the future. I do think we have to separate the response. The Rome Statute is not impossible to amend, but very difficult to amend. The Assembly of State Parties can adopt new amendments, but the amendments only become in force through a very cumbersome process that isn't about the assembly as a whole, but about individual states. And we haven't seen a lot of willingness of states to ratify new amendments to the Rome Statute, like the aggression amendments or the amendments about biological weapons. That was never going to go anywhere. This idea that, that we're going to keep attacking you until you amend the Rome Statute to exclude non-state parties from jurisdiction. That's the territorial jurisdiction of the court is one of the fundamental cornerstones of the ICC. It was one of the things that was, very carefully discussed, negotiated, incorporated into the Rome Statute. That was never going to go anywhere. In terms of just the rhetorical response, of course, it's easy to second guess and say, gosh, I wish the ASP had acted more quickly or had used more strident language to reject the United States. But the Assembly of State Parties, they're states, they're diplomats. I do think that they, made the statements that they had to make to assert the independence, the autonomy of the court as a whole. I think they've done, in general, a pretty good job of condemning the sanctions. Again, we could always wish for more, stronger language, but I think they made clear that U.S. attempts to kind of get their way through blackmail were not going to succeed. The U.S. can harm the court, clearly, but they're going to harm the court over the objections of many of their traditional allies. And so, it was good to see so many Western Europeans, so many NATO states that are members of the court denounce the sanctions and assert the independence and autonomy of the judges and the prosecutor. So, on balance, I think they did primarily the right thing.
And speaking of sanctions, so far the Trump administration has sanctioned many judges and the prosecutor of the court and his deputy prosecutors, even the UN Special Rapporteur on Palestine and Palestinian NGOs. But as an American who is engaging with the court, what's the risk to you personally?
So, this also needs some explanation. As an American who does not have any kind of dual citizenship, I cannot be directly sanctioned by the U.S. government pursuant to an executive order from President Trump. So I'm not in the same position as Prosecutor Khan, the 2 DPs, and the 8 judges who have been sanctioned. So that's the good news if you're an American. The bad news, if you're an American, is the existence of IEPA, the International Economic Emergency Powers Act. Oversimplifying a little because it would take us all night to unpack. IEPA says that anyone, including an American, who really in any way facilitates the work of someone who has been sanctioned pursuant to one of these executive orders, anyone who facilitates the work of a sanctioned individual commits at least a civil wrong and potentially a crime. If the government believes that, say, an American has willfully, intentionally facilitated the work of a sanctioned person, like the prosecutor, DPs, or judges, potentially that person is subject to a fine of up to $1 million and potentially 20 years in prison if they're criminally prosecuted for facilitating the work of a sanctioned person. So that's the threat that Americans face. And it's not an idle threat, and it's not an insignificant one.
Has it deterred you from carrying out your role?
I stepped away from my ICC work for a while, essentially because of the threat of IEPA being applied to me. Very quickly, there was a number of lawsuits brought against the possibility of IEPA being applied to someone in a position similar to mine, someone who is American working at the court, someone who is American who's a special advisor, someone who is an American who consults with the court. Number of lawsuits brought. Those lawsuits were extremely successful. One of the prosecutors in the ICC, who is an American, he filed a lawsuit in Chicago in federal court and was very quickly granted a license by the Trump administration to continue to do his work. The more important one, because that was settled, was litigation brought in the Southern District of New York by Lisa Davis, the special advisor for gender persecution who I had worked with on the gender persecution issues in Afghanistan, and Gabor Rona, who is a professor of practice at Cardozo, very experienced human rights advocate and litigator who has done a lot of consulting with the court. And they went to the Southern District of New York and basically said it is unconstitutional for IEPA to be used against an American on the basis of their speech. It was a First Amendment challenge. That they had a right to speak to the prosecutor, to the office of the prosecutor, to whomever at the court. That kind of litigation only possible if you're an American, because only Americans have those kinds of constitutional rights. There's a backstory that was actually kind of a continuation of a lawsuit that had been brought during the first Trump administration. These were not the first set of sanctions. There were also sanctioned individuals like Fatou Bensouda under the previous Trump administration. But he imposed those sanctions very close to the end of his term. But nevertheless, they were challenged in court, and there was a preliminary injunction against applying them to Americans granted by a judge in the Southern District. So in some ways, this was a continuation of that litigation. But in any case, the judge in the Southern District of New York, a federal judge, agreed and issued a permanent injunction saying that it would be an unconstitutional violation of Americans' First Amendment rights to essentially try to fine them or imprison them under IEPA for constitutionally protected speech. So the Trump administration didn't appeal that, and we can only speculate as to why they didn't. But I wasn't part of that litigation, so I'm not technically subject to the specific preliminary injunction, but that made me comfortable enough to essentially go back to work. It's impossible to separate my situation from Lisa Davis's. We're both American special advisors who have worked on either the Palestine or the Afghanistan investigation. So because she was legally protected, I felt that I was legally protected enough that I could continue to speak to the prosecutor and other people in the OTP. So at that point, I then picked my responsibilities back up and continued to work.
Concerning sanctions on the court itself, you've previously described it, and I'm aware that other people working at the ICC describe it as a potential doomsday scenario. What do you think would be the impact of the US taking the extraordinary step of sanctioning the court as an institution?
I don't know. The sanctions on individuals are terrible. They're terrible for those individuals. It dramatically transforms the life of a sanctioned person. And, Judge Gilou and others have spoken publicly about the effect it's had on them. From a systemic standpoint, those are survivable. Take those people out, essentially, but the court can still function. More difficult, you lose the input of some of the best people, but it can be compensated for. I don't know whether the court would survive institutional sanctions. It would require really an unprecedented level of cooperation and commitment from ICC member states, particularly the ones in Europe who are traditional allies of the US, who are members of the EU, who are members of NATO, essentially. If they didn't step up and take really dramatic action to protect the court, I don't see how the court could function. Institutional sanctions could literally lead to all the electricity being turned off at the court. If the companies that provide electricity felt that they were in legal jeopardy for facilitating the work of a sanctioned institution, they might say, nope, sorry, we're not going to give you electricity anymore. Internet providers may very well say, nope, sorry, we're not going to provide you with internet. The water supply, you might not have working toilets because somebody has to provide the water. They may say, sorry, the jeopardy is too great for us. How do you function as a court without electricity and toilets and internet? So I hope I never find out whether the court can survive that. But I cannot sit here and say that it could be compensated for. The court itself could not function without external assistance. It would not have the ability to overcome those sanctions. It would really depend on ICC member states stepping up and making sure that the lights stay on.
And yet the leadership of the ICC, including the president and also the deputy prosecutors, they have actually said that they do have measures in place to counter the impact of sanctions, and they seem to be confident that the court will survive.
I don't believe that they've actually said that about institutional sanctions, though. They definitely have taken measures to, alleviate the worst of the individual sanctions. But I don't think anybody has really publicly discussed the doomsday scenario, because no sense in publicly discussing it until it becomes real, and hopefully it never will. So I don't know exactly what statements you're referring to, but my own personal view is no matter what the court did by itself, it would not be enough to overcome institutional sanctions, and it would depend on other states stepping up.
So I was referring mainly to the president of the ICC's statements during the ASP, when she said that there are measures being taken, but that these measures are confidential. So nobody knows really.
Yeah, they're confidential to me too. So I can't comment on them because I don't know what specifics she's speaking to.
Professor Heller, are you concerned about the future of international criminal justice given the unprecedented attacks on the court, the sanctions on court officials, and the threat of sanctioning the court as an institution? Is it indispensable for international criminal justice, the ICC?
Is it indispensable? No. States have the right to prosecute international crimes in their domestic courts. Even the weakest states have resources judicially that dwarf the resources of the ICC. We could imagine a world in which states were the ones that really did take the lead in prosecuting these kinds of crimes. And we see some of that. I mean, via universal jurisdiction, there have been Libyans prosecuted, Syrians prosecuted, Russians prosecuted. That can continue, and it should continue. And I think there is a general, arc toward universal jurisdiction becoming more and more widely used, and not just by states in Northern Europe or Western Europe, but even in states like Argentina. That will continue, and it should continue. And if you ask me as an academic, that is the future of international criminal justice. It is at the domestic level, not at the international level. We have to acknowledge that the proliferation of international courts and tribunals that we have seen was very much a product of the end of the Cold War. The crumbling of communism, the dissolution of the Soviet Union, the Security Council for the first time in 50, 60 years actually starting to function. You would never have the ICTY, the Yugoslav Tribunal, or the ICTR, the Rwanda Tribunal, or even probably the Special Court for Sierra Leone created today. You certainly would never have the ICC created today. The world is too fractured. States would not, even the ones that are the members, would not support a court like the ICC. It was very much the product of a more optimistic time. So I do not in any way want to suggest that the ICC isn't important. It is. It's really the only game in town at the international level these days. It will always have important cases. It will always have the potential to be the universal court that its founders dreamed that it would be. But it is not an easy environment for the ICC to function. I would like to say that this is just a blip, and the next Democratic administration, the next Russian administration, the next Israeli government, will somehow fundamentally change the relationship between the court and states. I think that's overly optimistic. It will probably not always be as bad as it is now, but when you have an international tribunal that is not just trying to prosecute rebels and warlords in Africa, but are actually going after sitting heads of state of powerful countries, you're never going to be in a politics-free environment. You're never going to be in a coercion-free environment. It's always going to be a challenge. It will always have, the Medvedevs threatening to launch a hypersonic missile at ICC headquarters. It will always have Lindsey Graham talking about, in mafia terms, going after like the families of prosecutors at the ICC. You're never going to get beyond that. So I hope the ICC long outlives me. I hope the ICC will always have important cases to pursue. But it isn't the be-all and end-all of international criminal justice. It really is a court of last resort and not a court of first resort. And I, as an academic, I despair often of how every conflict is initially viewed through the lens of the ICC. What's the ICC going to do? How is it going to get involved? When's it going to investigate? When's it going to bring charges? Of course it will in a number of situations, but it is just one international tribunal, understaffed, under-resourced, constantly threatened, facing much more powerful adversaries. We need to get beyond looking at it as the court of first resort, and we really need to emphasize the role of states in pursuing international criminal justice. So I don't think international criminal justice is going anywhere. I don't think the ICC is going anywhere. But we really do weigh down the ICC in particular with expectations that it just simply is not structurally capable of accomplishing. So as long as we are modest in our expectations, as long as we don't expect the ICC to be plucking heads of state, out of their domestic situations right and left, as long as we don't expect it to fundamentally transform societies and bring peace and promote reconciliation, as long as we don't think it is going to do those things, we can celebrate the things that it is able to do and put it in a much more realistic light, and then be, cautiously optimistic about the future of international criminal justice. So the future of international criminal justice really depends on what we expect international criminal justice to do.
Professor Heller, that was an informative conversation. I really appreciate it.
Thank you for having me again. It was a pleasure.